Wonderful. I will go ahead and share my screen so that we can go ahead and get the presentation on the screen. Give me 1 second. Let me go ahead and enter presentation mode, and we should be shortly up and running. All right. I apologize for that. Give me 1 second. All right, so my name is Carla Jacobo, and I am a staff member on the Small Business Development team at Tzedek. Today, we are joined by the wonderful Celeste Al, who we will be presenting on commercial leases. Before we begin, I wanted to provide a brief overview about the Small Business Development Program at Tzedek. So I just wanted to cover some very important pieces of our program. We are designed to help low to moderate income entrepreneurs secure free assistance to a wide range of transactional business law matters through a variety of mediums, and this includes community and presentations and workshops such as the one today, small business legal academies. We share and distribute guides and other free resources, which we author as an agency and also co-collaborate with other agencies in the community, and we also assist with direct client representation. The way that we're able to provide these services is by providing services through an infrastructure and a support system that allows our small businesses to submit applications in an accessible way through an online application so that they can connect to our team and receive services in any of the areas that you see on your screen, anything from contracts to commercial leases to matters of employment law, both for staff attorneys and connecting them to our wonderful network of pro bono attorneys that have assisted and supported us along the way. In order to secure representation as a small business owner, we do an eligibility screening, and that screening involves a review of household income eligibilities. Profits and businesses are also factored in as well for-profit businesses in Los Angeles County. If you are a nonprofit, we definitely have some wonderful referrals that we can connect you into the community so you can receive services for your nonprofit. But for now, Tzedek Small Business Development exclusively focuses on for-profit businesses in Los Angeles County. And we do like to stress that we assist primarily with transactional matters, not litigation services. If you want to connect with us, you can submit an application for assistance online or send me an email at cjacobo@tzedek.org. All of these resources will be shared. We will follow up by sharing today's presentation and accessing our online application after the presentation. I did want to communicate that we are on a bit of a time crunch, so this presentation will run smoothly as best it can. I do want to take a moment to introduce the wonderful Celeste All, who is doing the commercial lease presentation. A little bit of background on her. She joined Alston and Birds LLP Real Estate Group in 2014, mostly representing lenders in origination of CMBS loans. Prior to that, she practiced general corporate law in Orange County. And in addition to her law practice, she teaches business law and ethics at CSULB. So we have a great mind with us today. She will be leading the rest of the conversation moving forward throughout today's presentation. I do ask that if you have any questions, please drop them in the chat and I will communicate and collect them at the end of the presentation so that we hopefully can get some great answers from Celeste or follow up with some great answers via email. Take it away, Celeste.
Well, hi, everyone. Thank you so much for having me here, Carla and Tzedek, and I appreciate you all taking time out of your schedule tonight to come here and learn more about your rights. We are going to move pretty quickly tonight. There's a lot to cover, but as Carla said, if you have questions as I'm going along, feel free to shoot them in the chat and we'll do our best to address them tonight or in a follow-up conversation. Did want to give a little bit of a disclaimer before we get started. So tonight's presentation is meant to be a high-level overview and helping you spot some legal issues that could come up in your business and specifically in your leasing transaction. Because there are so many factors to consider, this is really not meant to be specific advice in any given situation. So if you have, a specific question about your situation, we would suggest that you go to Tzedek and, seek representation for your business and your specific situation. Tonight is not meant to be construed as legal advice, and by coming here tonight, we're not entering into an attorney-client relationship. This is meant to be informational only. Nothing said during this presentation is confidential. So if you're putting something in the chat that is specific to your business, keep in mind that it's not subject to attorney-client privilege or confidentiality. With that said, let's get going. Tonight we have 3 broad topics that we're going to cover, 3 sections. First, I'm going to start off with a leasing overview, just very quickly listing the types of things you should consider when entering into a commercial lease. Then we'll get into a little bit more details about the key terms of a lease and some of the most important provisions to consider. And then lastly, we'll talk about what the eviction process looks like in commercial real estate and what going through terminating the lease or having an unlawful detainer process would be. So starting with the commercial lease overview, and we'll get into the difference between commercial and residential real estate. So commercial real estate refers to really various types of uses. It could be retail, office, industrial. In some cases, it could be multifamily if the property is big enough. The key factor in commercial leases is that the tenant's rights are governed almost entirely by the lease. So if you have a question about what your rights are, that would be the first place to look, is the lease itself. Contrast that to residential real estate, is the use is just for residential purposes. And a key difference there is that residential tenants enjoy significant protections under law. So in addition to what is contained in the lease protecting the tenant, there is a lot of statute and case law protecting residential tenants. For example, the right to have repairs made by the landlord and requiring the landlord to provide heat are some protections that are provided to residential tenants by law. And those same protections are not necessarily given to commercial leases. So as preliminary aspects to consider, all leases should be in writing, always, period. Another thing to keep in mind is residential tenants are afforded different protections under law than commercial tenants, including different protections under COVID-19 regulations. Commercial tenants, generally speaking, have fewer protections than residential tenants, so that's something to keep in mind. Tonight's presentation, we're just going to focus on commercial leasing. So if you are in the process of seeking out a commercial lease, here would be your timeline of events. First, for yourself, you should identify your needs and your bottom line. What is going to be most important for your business, both immediately and in the next few years? From there, you should consult professionals, and probably your team is going to have multiple professionals, a lawyer, certainly, more than likely a real estate broker, and then probably an insurance agent and maybe some contractors if you're going to do any building in the spaces. That team is going to help you identify and inspect a space, find a space that's going to work for your needs, both in the short run and in the longer run. At this point, you probably want to hire a contractor to inspect the space and pull records. Definitely, if you can get a contractor that's familiar with the regulations in that specific location, it's going to save you some headaches down the road if they know the types of permitting and restrictions that would be in place for the space. From there, once you have your team and your space in mind, you're going to submit an offer, which is sometimes called a letter of intent to lease the space. We're going to talk about what the letter of intent is a little bit more in a second. And then from there, you're going to negotiate and enter into your lease. So one of the primary things to keep in mind is whether you want to enter into the lease, and in fact, whether you want to do business just individually, or if you want to form some type of business entities. So there are several options you can take. Sole proprietorship is really just you doing business individually, but you could also do business as a partnership, a corporation, limited liability company. A few other options exist as well. That's definitely one of the things you would want to consult a lawyer about, helping you select and form your business entity. And the types of things you'll be considering when you make that decision is not only how is that going to impact your operations during the life of the business and the life of this lease, but how is that also going to impact your ability to exit the lease? So we're going to talk about exiting leases later, but the type of business entity you select might help you get out of leases easier later on down the line by insulating you from personal liability and having other aspects you can use to sell the business if you wanted to get out. However, keep in mind, especially if you're a smaller business or a new business, the landlord is going to be checking on the credit worthiness of the tenant entity. So if you select an entity that doesn't have really any operating history or not a lot of capital, your landlord might require you personally to enter into a lease guarantee. So that's something to keep in mind as well. All right, so we're going to circle back to that letter of intent. I promised we'd come back to it. So prior to entering into the full lease, the landlords and tenants often will negotiate what's called a letter of intent. So this is a non-binding agreement, but it's your opportunity to hammer out some of the most important terms, sort of in summary. Some of the basic terms are: who's going to be the tenant? Is it you, or is it one of those entities you selected? Are they going to require a guarantor? What is your rent going to look like? And are there any additional costs that you're going to be responsible for besides rent? And then do you have audit rights? Do you have the right to ask the landlord for supporting documentation about what those costs are? What the security deposit is going to look like, the length of the lease, and any options to renew. What specifically are you entitled to in terms of the premises that you're renting, and how are you able to use it? What condition are you going to receive the premises in, and what condition do you need to leave it in when the lease is over? And then during the term of the lease, what are you responsible for in terms of repair, maintenance, etc.? And are you going to get any tenant improvement allowances? I know I'm going quickly. It's because we're going to circle back to all of those things in more detail later. And from there, if you get through the letter of intent and you've hammered that out, the next part is to actually enter into the lease itself. So here we're going to go in a little bit more detail about what the lease should contain. So the most basic and important terms are going to be the ones on this slide. And again, we're going to go through these each in more detail. So I'll go quickly, but the lease terms and any options to renew, how are you permitted to use the space? And are you going to get any exclusivity in that use? Are you allowed to assign or sublet the space at all? What is your rent going to look like? And is it going to be on a gross basis versus a net basis? Are you going to be responsible for improving the space at all or repairing the space? And if so, is the landlord going to give you any sort of allowance to use towards that? Is there going to be a security deposit required? Any personal guarantee required? If there are any issues that come up during the life of the lease, how do you give notice? And is there any period of time it requires for that notice to be effective? What does a default under the lease look like for both parties? Are you required to continually operate in the space? What happens if the lease is over, but you're still in the space? That would be your holdover provisions, subordination and non-disturbance. So in all of these, you want to consider what are your most important things, and is there anything you're willing to negotiate or willing to give up? So at this point in the negotiations, before you enter into the lease, your leverage is your ability to walk away. And so that's not always going to be the case after you entered into the lease. So this is really your opportunity to think about if these terms are something you're willing to live with for the next, several years. All right, so let's start with lease term and options. So the term of the lease refers to how long the lease is in effect. And there are a few key dates that are going to be contained in the lease or can be contained in the lease And although they're similar, they're not always the same. So the effective date is the date you enter into the lease or the date that the lease kicks into effect. So there are certain restrictions that may kick in earlier than other restrictions. The earliest date that any of those would kick in is your effective date. Your commencement date is the date that you actually take over the premises. It's the date you get to enter into the space. And then your rent commencement date is the date you start paying rent. So those three dates certainly could all be the same date. They don't have to be. And so, particularly with respect to rent commencement, you want to ask, when would that start? Do you have to start paying rent the date you enter into the lease? Is it the date that you take possession of the space? It could be that you take possession of the space, but there are some repairs or alterations that need to be done. So you're not actually going to open for business until several months later. So maybe you want to negotiate that rent commences when you open. We'll talk about rent abatement a little bit later. So there could even be a later date that rent commences, or it could be a specified date. So one of the things you really want to pay attention to specifically is the rent commencement date. And then after your initial term, you might negotiate options to renew. And so those essentially are saying when the initial term is done, the lease renews itself under specific terms. So usually what happens is the tenant is given a time frame where prior to lease termination, where they have to decide whether they want to exercise their option to extend. So that's something you want to negotiate, 60 days, 90 days prior, 6 months prior, whatever it is. You want to make sure that it's enough time for you to do your research and make your decision on whether or not you want to extend the lease. For new businesses particularly, you may benefit from having a shorter initial term, but having more renewal options. And that just gives you some flexibility to get out of the lease quicker if it doesn't pan out the way you're initially imagining. So it allows you that flexibility of getting out while possibly locking in future rent. Typically with renewal options, the rent escalations or the rent increases are capped by CPI or a specific percentage that's named in the lease. Sometimes it jumps up to fair market value, and so that would be determined at the time of extension. But renewal options are great for preserving some flexibility and getting out earlier if you want to. Permitted use. So typically leases will limit you to a specific purpose. This is something you want to make sure you can, if you can, negotiate some flexibility, because if your purpose is too specific, it could be really hard for you to exit the lease if necessary. So you want to consider keeping the permitted use as general as possible. One, in case you want to change or expand your business model a little bit, or two, in case you want to sublet or assign the lease to a different business and exit the space altogether. And we're going to talk about subletting and assignment in a second. The other thing to keep in mind is, to the extent your permitted use requires any professional certifications, such as therapy, medical practice, etc., landlords are going to want ongoing evidence to make sure that you meet those professional certifications. Another thing that tends to go along with permitted use is exclusivity. And so exclusivity is the idea that you wouldn't want to have too many similar businesses on the same commercial property. You don't want to be competing with the person right next door to you. So an exclusivity provision is something you could consider negotiating to make sure that you're the only one in that particular commercial center allowed to have that permitted use. The other thing you want to keep in mind is whether any existing tenants have exclusivity provisions that would bar some of your operations. And if, on the flip side, if any of the protections that you're negotiating for would help you protect, from future tenants. So you're not only wanting to have exclusivity against current tenants, but potential future tenants that could move in later. All right, so we're going to swing back to assignment and subletting. So both of these are essentially ways for you getting out of the lease and having someone else on the hook for the lease liabilities, but they operate differently. So assignment is putting someone else in your shoes. So if it's the landlord and you're the tenant, it's literally just putting you out and swapping someone else in your place. And so there's a new tenant having the relationship with the landlord. Sublet, the original parties remain intact. So you have the landlord and you as the tenant, but now you're going to add another third party that has a relationship with you. So they would be the person in the space. They would be the ultimate tenant. You would be their landlord. However, you are still answerable to the original landlord. So you're kind of the middleman in the sense, but you have a new tenant in the subletting the space and paying you rent, which then you pass on to the original landlord. So assignment and subletting are both useful exit strategies. Typically, the landlord is going to start off by saying that you can't assign or sublet without their consent. They want to have say over who's in their space. However, there are several provisions that you could try to negotiate that give you some flexibility. So typical flexibility is they don't get consent rights if the transfer, so either the assignment or the subletting, is to an entity that's related to you, whether by merger, a franchisee, consolidation, equity sale, whatever it is. But if essentially the control stays the same and it's just a corporate reorganization, a lot of times they'll be willing to negotiate some flexibility with that. Sometimes you can get them comfortable not consenting if certain net worth and sometimes liquidity requirements are met. So essentially, if the person you want to transfer to has significant financial resources, a lot of times the landlord is more comfortable giving the assignment or subletting as of right. You want to try to limit the ability of the landlord to share in the profits. So it's typical for them to try to take a portion or all of what we call a transfer premium. So let's say that you find someone, just to make the math easy, let's say your rent is $1,000 a month and you find someone who's willing to sublet the premises from you for $2,000 a month. A lot of times the landlords are going to want to say anything above, we get to keep anything above what you would be paying in rent. So you'd want to limit the ability of landlord to take those profits, keep as much for yourself as you can. The other thing is if you did have a guarantor on the lease, you want to try to get them off the hook if you sublet or assign the lease. You don't want to have, potentially yourself personally still be on the hook for a lease that you're not really obligated under anymore. One thing that's also typical in commercial leases is for the landlords to have a recapture right, meaning that if the tenant requests to sublease and assign as an alternative to granting permission, the landlord can just say, okay, never mind, we're going to terminate your lease and take back the space. And although that sounds kind of harsh, this can be a good thing for the tenant. So if your goal is to get out of the space, and that's what you wanted anyway, it's not really a bad thing that the landlord says, never mind, we'll just terminate the lease and let you out anyway. All right, let's talk about rent and the different ways that can look. So starting with the difference between a gross lease and a net lease. And so on a gross lease, the tenant pays a base rent and the landlord pays any expenses. It can be set up to be modified in a later year so that as operations continue, the tenant pays additional expenses. The flip side to that would be a net lease, or in some cases, a triple net lease. So with these types of leases, in addition to paying a base rent, you're also going to pay your proportionate share of expenses. And in a triple net lease, those expenses are going to be taxes, insurance, and operating expenses. And so why would one be better than another? Typically, the base rent is going to be higher in a gross lease than it would be in a triple net lease. And so to the extent you have expenses that you can control or keep lower, that's why a net lease might be more beneficial to you. But things you want to consider: how are utilities calculated? Are they separately metered, or are you going to be sharing in common with other tenants? And you particularly want to consider that if one of your neighbors is going to be using like high levels of utility, you might be pitching in to subsidize some of their use. If you guys are just dividing it based off of square footage. Other things to consider are audit rights. Do you get to request documentation supporting what expenses the landlord is charging you for? So that's something you may want to negotiate in the lease. So another thing you may want to negotiate is an estimate of pass-through expenses. So you may want the landlord to tell you what these additional expenses are going to look like. And in some cases, you can negotiate a cap on increases or just an overall cap in how much you have to pay month to month, depending on your situation. Other type of rent that can come into play is percentage rent. So percentage rent is basically, sorry, if you could, yeah, perfect. Is basically a percentage of your sales. And it could be flat percentage of sales. It could be percentage of sales above a break point. So anything in excess of this amount per month, you're paying a percentage of that. And percentage rent is in addition to your minimum rent. So keep that in mind. All right, I'm ready now. Thank you. So let's talk about who's responsible for improving, modifying, or repairing the space. So in commercial leases, there's no implied duty to repair like there might be in residential leases. So in commercial leases, just whatever's written in the lease is what governs. So you want to pay attention to that. Typically how it works is that the tenant is responsible for maintaining its own premises. And so if you're operating a restaurant, for example, typically the landlords are going to require you to maintain the premises up to health code. And that can include maintaining things like grease traps, etc. So that can get quite expensive. And then typically on the flip side, landlord is going to be responsible for maintaining and repairing the structure of the building. So that could be the foundation, the roof, any building systems that go throughout the building, as a whole, the lobby and the common areas. Things you want to consider: you may want to try to minimize business interference by requiring repairs to be made after hours, just so that the landlord can't be coming in right during the middle of your rush, working on the roof or the HVAC or whatever it is. You also might want to negotiate rent abatements or termination rights if the landlord fails to repair or maintain the premises for an extended period of time. So they have something that they're supposed to be repairing, they don't do it. It interrupts your ability to conduct business. You would want to have some sort of protections like rent abatement or being able to terminate the lease if it continues past a certain period of time. The other thing you want to consider is alterations or improvements you make during the lease or at the beginning to build out the space. So typically, landlords are going to want to consent to any alterations you do during the term of the lease. So a middle ground you can do there, just to give yourself some flexibility, is try to negotiate for not having to get landlord consent if the alteration is cosmetic. So if you're just like hanging different pictures or painting a different color, you can try to negotiate things like that, not needing landlord consent, and small in value. So if it doesn't cost, high amount of money. The other thing you can try to negotiate for is what's called a tenant improvement allowance. So typically how that works is the landlord gives you a certain amount of dollars per square foot to improve the space. However, usually these tenant improvement allowances can only be used for things that increase the value of the property. So the landlord's going to want to pitch in things that makes their space inherently more valuable, not just things that are useful to your specific business. And then finally, you want to negotiate the surrender conditions beforehand. So you want to negotiate out, once the lease is over, what are you allowed to take with you versus what has to stay behind in the premises. All right, so we're going to talk a little bit more about building out the space. So the lease is going to divide things between the landlord's work versus the tenant's work. So who's responsible for what? So a tenant's work would be building out the space. Typically how that works is you are going to submit plans that are subject to landlord's approval, and they have to comply with law. And then they'll do checks along the way to make sure that you've been building according to the plans. Usually the tenant is going to pay for any of their own work that they do. However, if you were able to negotiate that tenant improvement allowance, sometimes you can get the landlord to contribute. But this is also why that rent commencement date was important. It's helpful if you can give yourself some time to finish building out the space before you need to start paying rent, so that you're not having to pay rent when you don't have business operations helping you make that profit to pay the rent. You can also try to negotiate for the landlord to do some of that initial build out. And so you want to negotiate, what does the space need to look like before it's handed over to you to do your work? So is there any work that the landlord needs to do to make the space ready for you to come in and do your final build out? You also want to consider timing. You don't want the landlord to be dragging their feet and making the space ready for you to do your thing. So you want to have some requirements that the landlord completes their work before the lease commencement date begins. Certainly before you have to start paying rent, you want landlord to be done with their work. And so one of the things the landlord's going to push back on is, let's say the landlord is delay, but the delay is really the tenant's fault. So let's say the landlord hands it over to the tenant to approve, and the tenant just sits on it for a while. The landlord's not going to want to be penalized. So working out some sort of system where, you know, the landlord has a timeline to turn it over to you as the tenant to approve, but then you have some incentive as well to review and approve the work that the landlord did. Another thing to be, back just one more. Another thing to be aware of is if you are taking a space as is, that can be a little bit tricky. So you want to at the very least make sure that the space is free and clear of personal property from the prior tenants. You don't want to get a space and have to do a lot of work to it initially just to clear it out. So anytime it says as is, you may want to at least consider making sure it's free and clear of any personal property from prior tenants. Security deposit. So security deposit in commercial leases can either be a cash deposit or letter of credit. In terms of the amount of the security deposit, it's typically 1 to 2 months rent. Usually the security deposits are due at lease execution. So you don't typically get that leeway with the security deposit. A couple of things to keep in mind that can give you flexibility during the term of the lease. One would be to negotiate a burn off of the security deposit. So maybe the security deposit starts off higher, but then during the term of the lease, you gradually get some of that back as you've shown that you're responsible. The other thing to negotiate is what specifically can the landlord deduct from that security deposit. So is it overdue rent? Can they deduct, you know, repairs that you're supposed to do? What specifically are they allowed to take care out of it? And so one thing to keep in mind in commercial leases is that if the landlord uses part of the security deposit, they can require the tenant to restore the security deposit. So again, just to make the math easy, let's say you started off with a $2,000 security deposit, the landlord uses 500 of it, they can come back to you and require you to deposit another 500 to bring it back up to that initial 2,000. Tenant does have some statutory protections about getting the security deposit back. So if the security deposit exceeds the first and last month's rent and is used to cover only defaults in payment, then any amount exceeding 1 month's rent must be returned within 2 weeks of landlord receiving possession, and the remainder returned or accounted for within 30 days. So it's basically timelines for the landlord having to return your security deposit after the lease is over. Landlords will frequently ask for this particular code provision to be waived. So if that's something that they're asking for, then you definitely want to ask your attorney what the repercussions of that would be. Personal guarantees. So this has come up a couple times in passing, but let's talk about what that means. So a personal guarantee makes a warm body individual liable for the lease agreement. And so that comes back to the context of maybe you entered into the lease as a business entity instead of as yourself personally. If that business entity doesn't have significant operating history, the landlord might want additional protection in the form of a personal guarantee. So that would put, it could be you as the individual business owner on the hook, or it could be a third party. I've seen parents give a personal guarantee. I've seen spouses. I've seen business partners give personal guarantees. But the end of the line impact is that an individual becomes on the hook for the lease obligations. This deeply impacts your exit strategy, because even if you're able to assign or sublet your lease, or if you want to consider just, you had thought that you had some personal liability shields by entering into an LLC, for example, those protections went away because you have this personal guarantee that's a separate agreement. And so if the landlord is asking for a personal guarantee, there are some things you might be able to give them instead to get out of it, such as potentially a higher security deposit. So instead of giving a personal guarantee, maybe they'll accept more money as the security deposit. But you definitely want to think about the impacts on your personal assets versus your business assets if you're using a separate entity to conduct your business. And so that's definitely a question to ask your attorney when you're in this situation. There are various things that can happen during the term of the lease where you and the landlord are going to want to be able to contact each other. And so one important provision to talk about is, how do you do that? How do you give notices under the lease to each other? And how long before that's effective? So some of the types of things where you might need to give notice to each other would be rent increases. So if the landlord's trying to get a hold of you that the rent is going to go up, if one or either of you is going to terminate the lease for whatever reason, or if there's a default that needs to be cured, if there are going to be any other modifications of the lease terms, and then whether the landlord is able to enter onto the property. That's not the whole list. There could be many reasons why you need to get a hold of each other. But a couple of things to keep in mind in the notice provisions. One, you want to make sure that the address in there is actually the best way for them to get a hold of you. You want to make sure that you're receiving those notices. And then two, you want to make sure that whatever notice period you're given is actually enough time for you to do something about it. And so under California law, there's no guaranteed minimum notice period for commercial leases. Whatever the lease says is your amount of notice is what you get. So you want to read carefully. And you want to negotiate a notice period that works for you. And you want to think back to what's your leverage. Well, at the beginning of the lease, before you've entered into it, your leverage is your ability to walk away. During the lease, more so it's that you want to have, both parties want to have a smooth relationship with each other. They don't want to have to evict you. So you want to make sure that your notice period is long enough for you to actually, comply with the lease and to fix any issues that are coming up. All right, let's talk about defaults. And defaults could be on either side. It could be the tenant that's defaulting under the lease or the landlord. And so typical tenant defaults would be monetary defaults, meaning you didn't pay rent or some other amount that's due under the lease. Or it could be non-monetary defaults. And so those would be any other obligation you had under the lease besides paying money that you failed to perform. So maybe making a repair, for example. For any of these defaults, you want to try to negotiate notice and cure. So, hey, you need to let me know that I defaulted, but you also give me a period of time to make it right. Typically, monetary defaults are going to have a shorter period of cure, and they might be willing to negotiate a longer period of cure for non-monetary defaults. However, after the notice and cure period, the landlord has various rights under the law And typically they'll put these in the lease as well. So some of the things they can do after a tenant default would be to apply the security deposit, to terminate the lease and sue for damages, to re-let the premises and collect leasing costs. So basically give the space to someone else and sue you for the amount of leasing costs and any difference in rent, any deficiency in rent. They can keep the lease in place and sue for rent as it comes due. That's given under California Civil Code 1951.4. And then if there was a guarantor on the lease, they can also sue the guarantor for damages. And sometimes they can pursue these concurrently, whatever it takes to make them full. One thing you want to avoid, if you can, is accelerated rent, meaning the idea that the landlord would charge for the entire term's worth of rent all at once. So you want to try to negotiate that out if you can. You also want to include a waiver of consequential damages. So you want to limit damages you're on the hook for to actual damages if you can. On the flip side, there are various ways the landlord could default under the lease. So tenant could negotiate for interruption of services. So for example, if the landlord was supposed to maintain utilities and they didn't, so power's out for a week or something like that, you can negotiate that being a default, entitling you to damages or terminating the lease. You might be able to negotiate for rent abatement, so paying less rent if the landlord is actively in default. One of the things to keep in mind is in commercial leases, there's no warranty of habitability. That's different than residential leasing. So you can't do the repair and deduct thing automatically like you would be able to in residential leases. You might want to negotiate self-help rights. So let's say the landlord was supposed to repair something and they didn't. You might want to negotiate the ability to make the repair yourself and withhold rent or deduct rent. Other remedies you could negotiate for would be to sue the landlord and or to make a claim for constructive eviction, meaning that basically by failing to uphold the lease, they're evicting you. Continuous use covenants. So especially in retail settings, it's typical for a lease to have what's called a continuous use covenant, meaning they're going to require your business to remain open, during normal business hours every day. And so be careful if your business shuts down at certain times of the year. If for whatever reason you can't guarantee that you're going to be operating continuously during normal business hours, that's something you want to put in the lease. So it could be that you operate a seasonal business, so you want to specify certain times of the year when your business is going to be closed. But certainly you want to negotiate for things like you can close during renovations, or you can close if there was a casualty, or maybe you need to close, 1 day a week or a couple hours early to do an inventory count. Consider all of those factors and carve them out of your continuous use requirements if you need that flexibility. Holdover. So we're kind of going through the life cycle of the lease. Holdover refers to the lease has expired, but you're still in the location. So you want to be really careful of the holdover provisions. Typically, the consequence of that is that the rent jumps up by quite a bit. So, up to 150% is common. So you just want to make sure that you're aware of what the provisions say. What are you supposed to do when the lease is over? If you intend to stay past the term of the lease, you want to make sure to give yourself plenty of time to negotiate an extension or a lease renewal, because especially if your lease says you don't have a right to hold over, because there can be some pretty significant financial consequences if you're still in the lease after the lease has expired. Also relating to holdover and surrendering the space, you want to be really clear about what condition do you need to give the space back in, and what are you allowed to take with you. So certain of the alterations or improvements that you've made, are you allowed to take those? So usually how it works is that anything that's movable personal property, so anything not bolted down, and any trade fixtures, so things specific to your businesses, like menus maybe, can be taken out. On the flip side, things like fixtures, so cash registers, counters, tables that are bolted down, typically those have to stay in the space and they become the landlord's property. So if there's anything you know that you want to be able to take with you at the end of the lease, you want to specify those early to avoid confusion. Signage can be difficult. So signage is definitely something that's typically, bolted to the space there, but you want to make sure you know who's responsible for taking out the signage, but also repairing any damage from removing the signage. Because that, is an additional expense and some work that would need to be done at the end. So if you as the tenant don't surrender and vacate the premises in time, that would trigger those holdover provisions we were talking about. The other thing to keep in mind, though, is if you leave behind personal property that you had the responsibility to remove, it can be considered abandoned, and the landlord rather is able to dispose of them. So sell them, throw them out, whatever. But the cost of getting rid of that personal property would be charged to you as the tenant. And so all of these obligations can get costly. So make sure that you understand your surrender obligations before you enter the lease. And then as the lease is coming to an end, you're being proactive about making sure you're getting the space back in the condition it's supposed to be in. All right, subordination and non-disturbance. These typically relate to the landlord's financing the property. So you want to be clear who owns the property you're leasing. Typically it's the landlord, but the thing to keep in mind in the background is that the landlord probably has its own mortgage on the property. So they own it subject to a mortgage. And their lender is going to want certain protections in the lease so that if the lender ever foreclosed and took over the property, they would have certain rights with respect to the tenant and the leases. And so the law can get tricky about what happens to your lease if the property is foreclosed on. So you want to make sure that if a new owner steps in to the landlord's shoes, they're not automatically able to just kick you out. And so what's really typical to put in a lease is called subordination and non-disturbance provisions. And you as the tenant really want to make sure that the non-disturbance provisions are in there. And so including a non-disturbance and a torment clause says that you can't be evicted or ejected as long as you're not in default. So as the tenant, really, you're okay having a subordinate lease as long as you get those non-disturbance provisions in there, guaranteeing that if you're not in default, they can't just kick you out of the property. Tenant's insurance. So the lease is typically going to require the tenant to maintain casualty insurance for any property damages, but also liability insurance for any damages to persons or property of others. There may be additional insurance requirements that the landlord puts in there as well. Early on in the process, ask your insurance agent to review those provisions in the lease, one, to make sure that you can, obtain those insurance, the required insurance at a rate that works for you and your business, but also regularly review the policy to ensure compliance. You don't want to fall out of compliance with the insurance provisions. You're going to want to work with your agent to make sure you obtain your certificates of insurance to prove your current coverage. And you really don't want the coverage to lapse. There can be some pretty harsh penalties for that. So that's a conversation to have regularly, and read the lease to make sure if they say, the lease says you want to provide annual evidence of renewal, you want to make sure you're providing that evidence of renewal. The other thing is there are some little nits that you want to make sure that you have covered. So there might be, for example, an additional insured, could be your landlord, could be the landlord's mortgagee, whatever it is, you want to make sure that the lease says you have them as additional insureds, that you've got that covered. All right, we're going to move on to the third section. What happens if the lease heads into eviction? So how do you terminate the lease, and what does an unlawful detainer look like?
And Celeste, before I go on to the next screen, I want to let you know that we've hit the 10-minute till 6.
All right, I'll go even faster. Thank you. All right, so unlawful detainer is the term for the legal procedure to terminate and evict a tenant. So in California, in the commercial space, there are some minimum legal requirements, but otherwise it's governed by the lease terms. So the procedure for that is that the landlord's going to send you a notice of termination. And from there, they're going to instigate the formal court process, which is filing a summons and a complaint. From there, you get the chance to answer. There's a discovery period, any pretrial motions. Then you go to trial. The trial results in a judgment. If the judgment goes against you as the tenant, from there you would be issued a writ of possession, which gives the landlord the right to take back the premises from you. So quickly through this, the notice of termination is basically saying the landlord's notice to you that they intend to terminate the lease. The notice period is going to be in the lease, so they have to give you a certain amount of advance warning. If you're on a month-to-month tenancy, they can terminate you at the end of the month without cause. Otherwise, they're going to give you a cure or quit, meaning either give back the space or cure your default. If the default is not paying rent, the notice that they give you has to state what the estimated unpaid rent is, or if it's for any other type of breach of the lease, they have to state what the breach is. If the type of breach you have is something that cannot be cured, instead what they're going to give you is notice to quit, which is basically saying just give back the property. Either one of the notices they give you have to give a notice of forfeiture. From there, if the notice period goes by and you didn't cure whatever default exists, the landlord is going to start suing for possession. So that process is them filing a complaint for unlawful detainer, along with any other initial documents they need to file. From there, you as the tenant would receive a summons to come to court. So the landlord is going to have to serve the summons, their complaint, and any other documents that they had to file to the tenant. And the law requires personal service, and they have to prove to the court that they personally serve you. From there, once you're served, you've only got 5 days to file and serve your answer and demand for a jury trial. So it's pretty quick succession. All of these forms can be found on judicial council forms. So that's something available on California website, and something certainly that your attorney could help you navigate. From there, both parties have a right to discovery. So your discovery process is gathering, evidence. So you have the other side produce certain documents, answer questions, admit whether certain statements are true or not. And all of this evidence is admissible at trial. From there, the landlord is going to request a trial date. And at trial, the landlord has to prove that they lawfully terminated the tenancy. In other words, they followed all of the steps that they were supposed to follow and gave adequate notice. They're also going to have to prove the amount of monetary damages that they suffered. After that, tenant gets to put on whatever defenses they have, as long as they were put in the answer that they filed. And once the trial is over, it's determined who is the prevailing party. So if the tenant wins, you get to stay in possession and the lease continues. If the landlord wins, they get to recover possession of the premises and they get a award for damages. Attorney's fees is basically whatever the lease says it is. So you aren't automatically going to get attorney's fees if you win the court case. So that's something to keep in mind to negotiate in the lease. If the landlord wins, so if they get the right to recover possession, in order to physically recover the property, the landlord's going to get a writ of possession, which is enforced 5 days after serving by the levying officer. So again, quick timeline there. And in terms of enforcing any monetary judgment, there are various methods they can have for enforcing monetary judgments. But the impact, if you do have an eviction on your record, it's not great for your credit worthiness. It's going to drive down credit score, and it's going to make it a lot harder to rent other spaces going forward. All right, so I know that was quick. We have this slide for you for resources that Tzedek puts out, and Carla was nice enough to put her contact information, but we do have a few minutes for questions.
I'm taking a look at the chat, and it looks like we don't have any questions in the chat. So if someone has a question, you're more than welcome to raise your hand or just put it in the chat now. Okay, wonderful. So I do just kind of want to provide a bit of information as reflected on the screen. You can always visit our website, but first I want to thank Celeste for giving us that wonderful presentation. We really appreciate all of your hard work. We do have some free resources on our website. You can always send me an email and I will follow up with everyone sending this link. So all the folks that registered so that they can go ahead and access some resources over on our website, and for our program, it's the same information reflected here. So I'm going to stop sharing my screen and we will return to the presentation. So I just wanted to give one more opportunity for anyone to ask any questions that they may have. Okay, wonderful. So I see that we do not have any. Once again, thank you so much, Celeste, for joining us. For all the folks that joined us today, we really appreciate you taking the time to tune in and learn from such a wonderful mind about such an important subject for all of our small businesses.
My pleasure. Thank you so much.
Thank you. Have a wonderful afternoon, everyone. Good night.